Okay, it's 2:30. We'll resume the meeting. We're now up to agenda item 6 for the update, discussion, and possible actions on 2025 legislation impacting the board, DCA, and/or the veterinary profession. Okay, we have Justin.
Okay.
Okay,
Yes,
go
thank
ahead.
you. So yeah, we'll first go over the priority legislation and then move on to the board monitored legislation. And I'll just go in order here. I'm on page 1 of the memo. The first bill listed is AB 516. This pertains to RVTs and veterinary assistants. This bill would authorize RVTs and veterinary assistants to perform animal health care services not otherwise prohibited by law under the supervision of a veterinarian, and would authorize both RVTs and veterinary assistants to perform animal health care services not otherwise prohibited by law on animals housed in public or private animal shelters, humane societies, or societies for the prevention of cruelty to animals pursuant to an order of a veterinarian. The bill would also authorize an RVT to perform dental care procedures, including tooth extractions, under the supervision of a veterinarian. Just wanted to point out, board counsel has noted that comment at the bottom of page 1, that if no changes to BPC section 4840 are made, the board would need to potentially review CCR sections 2035, 2036, and 2036.5 for conformity with the omitted version of BPC section 4840. It's believed that the board cannot list additional prohibited acts in regulation that are not otherwise listed in BPC section 4840.2. And the fact sheet for this bill is attached to the memo. So I'll pause there to see if there are any questions or comments from the board members.
Okay, so do we have any comments? This is up for discussion.
I just had a quick question. I mean, some of the language under the supervision of a veterinarian licensed or authorized to practice in the state. Can you be authorized to practice veterinary medicine if you're not licensed in California? How could you be unlicensed but yet authorized?
Recently, there was a federal law that was passed that if they're licensed in another state in active military, they can also be authorized to practice in this state. It was a federal law, the SCRA, and I'm going to blank on the acronym. But yes, there is the ability. They essentially would do a short registration process through DCA's website in order to get onto a list that they're registered. And then they can begin practicing in California or any other state that they become registered in. And it's just a list that's maintaining that they fit under that category. So and that was a federal law that was passed. So yes, it's small, but it's under that specific act.
Does the board affirmatively do something to say you are now authorized because you've come that path to try to practice either through the military here in California? So now they seek permission that we then authorize them to do that?
The board is not authorizing and we're not giving permission. The federal government gave that authorization if they met that criteria already. So but it's not something the board did or is authorizing.
Okay, so we wouldn't have any role. They would just be, by federal law, they'd be able to come and practice veterinary medicine?
There's a minor process where they provide us information, and there's a system that DCA created in order to enter that information in and say, yes, we have the information, and then they're added to this list. But it's not necessarily us authorizing, it's just us documenting that we received the information from them, that they now meet the criteria in the federal law.
Thank you.
I am concerned that it doesn't say the type of supervision, and I understand that it's defined elsewhere, but I think it's defined elsewhere. I don't think there should be any reason why it's not defined here in C.
Any other comments?
So the board has, they can take no position if they want to, we can continue on to the next item. You can take a position and then take public comment on that proposed position, but that's up to the board. So if there's no proposed position, we can move on to the next one.
Is there any position that the board wants to take at this time? I see no reaction for the board members. I take that as a no. So the board has no position, so we proceed to the next one.
Okay, moving on to the second bill on page 2, the top of page 2, AB 867. This bill pertains to cat decline. Under the staff comments, you can see kind of the history of just previous legislation on the topic of cat decline. I won't go through all of it, but it's there. Historically, the board has taken an opposed position on at least the previous bills that had been introduced. There was a bill last year on this topic, AB 2954. That bill failed to advance in 2024 and died in committee. This particular bill would prohibit a person from performing a decline or similar procedures on any cat unless the person is licensed as a veterinarian pursuant to our act, and the veterinarian is performing the decline for therapeutic purposes as defined. The bill would require a veterinarian, if they determine decline is necessary for therapeutic purpose, to file a written statement with the board that includes, among other information, the purpose for performing the procedure. The veterinarian would also be required to provide a copy of that statement to the owner of the cat. And again, attached to the memo is the fact sheet from the author's office on this bill. So again, I'll pause there to see if there are any comments or questions.
Point of clarification, when it says on a cat that is a member of an exotic or native wild, is it only prohibiting decline of wild cats? Maybe I'm just reading it incorrectly, but it seemed like
No, it's all cats.
it says on a cat that is a member of an exotic or native wild cat species.
I think they're just identifying specifically because of what you call this, like those the species, special species, but the bill is actually written for all cats.
And I think you're looking at the Ledge Council's digest. So it's like their summary of what's existing law and then the summary of what the new bill does. When you get down to the actual bill language, it's all cats. So where it's referencing exotic now, that's telling you what existing law is.
All right, so do we have a position on this bill? Anybody? Okay, I see Dr. Bradbury's hand. Go ahead, Doc.
Well, I mean, we've consistently opposed these bills, and I think it's because it's, telling veterinarians how they should practice veterinary medicine, and making prohibitions. I guess I've had a few surgeries myself, and it is pretty painful, and this procedure does seem to be does seem to be painful in cats, and I guess I understand why we've opposed it in the past, but it doesn't seem like it has taken away the rights of veterinarians in the other countries that have done this, other states, and I don't know particularly how this is causing consumer harm if I guess consumers want the option. So anyway, I feel like we've just blanket opposed this, and I sometimes think we need to sometimes take a fresh look at things, but I don't have a strong opinion either way.
The language in the bill that I'm reading says it also imposes a duty that the veterinarian shall prepare and file a written statement with the board setting forth the purpose for performing the procedure and providing the date on which the procedure was performed. Is that unusual, or is that a new burden that is being imposed?
That is definitely unusual. There's no requirement for veterinarians to report procedures to the board, and I'm not quite sure what we would be expected to do with that information other than report to us. We're not opening up investigations. We're not taking action. It's just reporting to the board that this procedure was done, which then arguably may be subject to PRA requests. And if they get data from the PRA requests, they could use that to negatively impact the veterinarians for performing services. So there's the concern there that if data's provided to us, we would then submit that as a Public Records Act request. So there's a concern there.
All right, I guess a question, are we taking a position? Are we continuing with our previous position of oppose?
I would not support this just in that respect right there, and I see it too, and that's more staff work, and I don't understand why we would be requiring that or even support that from a, yeah, from the board aspect. So I don't see how we can support that. But so I would take no position or oppose, but that would be.
When you say opposed, is it flat out opposed for that reason, or is it opposed unless amended, and then potentially go neutral if they struck it out? So what are you when you say opposed?
I guess I'd probably rather hear from other board members to see how they feel about this in general before I say completely one way or another.
I guess the biggest concern that I have here is then again, why are veterinarians being kind of dictated on how to practice medicine? The procedure to be done requires judgment of a veterinarian, and I think I would trust each veterinarian to do the right thing, and discouraging people to do this for cosmetic purposes. That's part of like education, I guess, educating the veterinary community, pet owners about the why it's not a good idea, but to actually put it in legislation to really tell the veterinarians on how to practice medicine. I'm having a little bit of a problem with that one. So are we making a position?
I'm in favor of opposing.
Is that a motion?
I motion to oppose this legislative bill.
I second.
Okay, now, so we open the floor for public comment for AB 867.
Hello, my name is Grant Miller from the California Veterinary Medical Association. AB 867 marks the sixth attempt for animal rights activists to ban the procedure of cat declawing in the state of California. The CVMA has traditionally been opposed to any measure that dictates how veterinarians practice veterinary medicine. The CVMA believes that decisions to perform procedures should be made by clients and their veterinarians, and in cases of declawing, only after all alternatives have been explored. The veterinary profession has adequately regulated itself in regard to the declaw procedure, as several major corporate conglomerates do not offer the procedure. It's not taught in either of California's 2 veterinary schools, and the CVMA itself has an outward-facing policy that discourages declawing for non-therapeutic purposes. The veterinary profession has moved away from this procedure by its own efforts, and thus the CVMA does not believe that it needs to be made into a crime. Thank you.
I see no other comments in the room. Moderator, could you please open up a line for those participating remotely?
Yes, indeed. WebEx is open on AB 867 and the motion. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise a hand. And as a reminder to our mobile device users, you may need to hit the ellipses button, that's the ... in order to find your hand. Our first request comes from Carrie Clay. Hold on just a moment, please. We're sending you a request to unmute your microphone.
Hello, can you hear me?
Yes, go ahead, please.
Okay. Yeah, I'd like to address the members of the board. And for one thing, I'd like to say that I think that data has to be addressed in terms of the numbers of declaws actually performed in California. I know from being a member of groups that are anti-declaw that there are many places that offer this, and that's anecdotal evidence. I don't have numbers, but I state that plainly, but I feel that someone needs to give numbers. Point number two is, I think for the board to state as a principle in ethics that declawing is cruel. It can cause problems with elimination, like cats won't use their litter boxes. It can make them very unhappy and difficult to live with, so they may end up in shelters. I just think that this is a very considered position to take if you take the opposed position. And lastly, I would like to know what exactly are the therapeutic benefits of doing this. I mean, anyone who would, even the declaw law just says therapeutic. I just don't see how this can be therapeutic. I think it's an ethical and a practical tragedy. Thank you. I'd welcome any comments because I really don't understand what therapeutic could possibly mean.
I guess there's a member of the feline community that wants to make a comment. We're hearing a cat meowing in the room. So,
The cat meowing in the room was in the background of Carrie's microphone.
okay. All right. Are there any other public comments from our online participants?
None online.
Okay. Thank you so much.
Ready?
I was just going to say, so before, can I say one?
Yeah.
Okay. I do appreciate all the cat comments that we've had today and yesterday. It's been very fun. It's helped lighten the mood. I would say that we do hear everybody when they're discussing this, and it isn't that, it isn't that we're not hearing you. I believe that we're just saying that there are many procedures out there that I believe the profession is going away from, and that the profession is saying by encouraging that, we're saying UC Davis and Western, it's not even being taught anymore. And I think that's the way that we're trying to support this measure, but by saying that it dictating, if we say that veterinarians should not be doing something, or by putting it in law, there are many things that become outdated and should not be done or should not be performed, then again, we go with the lists. And that's what we try to state our positions in different ways, and we try to support things in different ways. And so this is just not the way of doing it. And we do hear you. So I hope that makes sense.
All right, hearing no further discussion, we will now. Oh, I get, okay, Dr. Bradbury, sorry, I didn't see your hand.
That's okay. I know it's not supposed to be a back and forth, but therapeutic reasons would be a tumor of the digit at the nail bed. There's some infections. There's a variety of things affecting the nail bed and the nail that would require declawing. So I just wanted to share that.
Okay, so now we proceed to vote on the motion.
The motion is to oppose AB 867. Ms. Pulowski,
Yes.
Dr. Bradbury,
Yes.
Mr. Espinoza,
Yes.
Dr. Grant,
Yes.
Dr. Maniac,
Yes.
Dr. Solocito.
Yes.
Motion carries.
Okay, we proceed to AB 489.
Okay, moving on to page.
No, sorry, it's 1458.
Correct, yes.
Sorry.
Yeah, AB 1458 on page 3 of the memo. This bill pertains to animal physical therapy. This bill would proposes to make updates to the Physical Therapy Practice Act. It would authorize licensed physical therapists who meet specified education, training, and experience requirements to provide animal physical therapy as specified. The bill would require the physical therapist to notify the Physical Therapy Board of California of their practice of animal physical therapy. The bill would require the animal physical therapy to be provided under either of two sets of circumstances involving a licensed veterinarian who has established a VCPR with the animal. The first set of circumstances would be under the direct supervision of the veterinarian at a premises registered with the board. The second set of circumstances would be pursuant to a referral from the veterinarian, would require the physical therapist to provide a specified written notification to the owner of the animal patient, and would require the physical therapist to hold an active practice agreement with the licensed veterinarian. The bill would require the physical therapist to provide a written copy of that active practice agreement to the board or PTBC upon request. This bill would also make any physical therapist providing animal physical therapy solely liable for delegated animal physical therapy tasks performed pursuant to a referral from a licensed veterinarian or by a person under the direct supervision of the physical therapist. The bill would also specify that the veterinarian who issues an order for treatment for animal physical therapy is not liable for the animal physical therapy provided pursuant to that order by the physical therapist or by an aide or other assistant supervised by the physical therapist. The next paragraph at the bottom of page 3 just outlines disciplinary provisions. I won't go through those in detail. Over on page 4, we provide a little bit of background under the staff comments section. It refers to a prior bill from 2023, AB 814, that would have proposed to authorize licensed physical therapists to be registered with our board as a registered animal physical therapist and to provide animal physical rehabilitation if specified requirements were met. That bill did not advance any further in 2024. So just a little bit of background. We've also provided the fact sheet for this bill, as well as some comments we've received from the Animal Physical Therapy Coalition. And with that, I'll pause again for comments and questions.
Members, I just wanted to raise logistic concerns. I'm not going to weigh in on the policy. That's all for you to discuss. But logistic concerns that I have with this is that there's no requirement that either board, physical therapy board, or our board license or register these individuals. There's no requirement for anyone to verify the requirements in B. So the way that it is written, it would essentially be a reactive enforcement to where if the the physical therapy board received a complaint, they would have to see first if they met the criteria and ask for proof of that in order to take any kind of action to say that they violated B and they didn't qualify, which is typically not how it's done when you're issuing when you're allowing them to do an additional scope of practice. So logistics, it makes it hard for either board to enforce when it comes to B. And then in section C, it talks about a report of any final disciplinary action against the licensee of this chapter by the board, by our board. We don't license them or register them. So we don't have authority to discipline anything that we don't license or register. So C is essentially nothing at this point, and same with D, them notifying us notifying the board, so that the physical therapy board notifying us of their disciplinary action. Again, we don't have anything to do with that because we're not licensing or registering them. And by putting it into our act, that's going to eliminate a lot of the unlicensed practice cases that we get, because the cases we get are physical therapists who are practicing on animals that aren't licensed to do that. So that caseload would eliminate, and the only time we would get the unlicensed practice cases if physical therapy board found that they were doing, or we found that they were doing certain things and they weren't a licensed physical therapist who had those, who met that criteria. So it potentially could reduce unlicensed practice or come out as a wash because we would still investigate it. But as far as enforceability, I have just the logistical concerns that neither one of our boards are issuing a license or registering, and there's no disciplinary action to be taken.
Any comments from board members? Mr. Espinosa?
So is it fair to say this increases the responsibility of this board, provides it no additional resources or funding, and really suggests that we somehow have a role in enforcing this new group, but yet a physical therapist, but really hasn't expanded the responsibilities in that regard with respect to licensing and enforcement, but suggests that the board would have to author a report of final disciplinary action against this licensee who is licensed by some other entity?
So I don't think it actually does much to our board as far as any workload is concerned. But D just would never be triggered because we never, I'm sorry, C, the report of any disciplinary, because we don't take disciplinary action against non-licensees. So C is stating that there's some kind of report that the board is providing to the physical therapy board, but that report would never happen because we never take disciplinary action. So there's really not much impact to our board at all with this. But to the physical therapy board, if they are operating under the assumption that they would apply and have to verify that they meet the criteria, there could be an impact to the physical therapy board. But right now, there's no requirement that either board license or register these individuals after, or verify that the education components are done. So it's just these sections are not enforceable, I guess, or it makes it really challenging to enforce.
To build on that, so if the veterinary medical board took action against a licensee of the Physical Therapy Board of California, it would be as a citation for unlicensed practice because there would be no license issued by the veterinary medical board to the physical therapist. So that a citation is an enforcement action. It's not formal discipline. So that's what she's describing there. There would be no report of disciplinary action because if any action was taken by this board, it would be an enforcement action in the form of a citation. I also had some concerns about, I think it's subdivision A7. There would be animal facility requirements. I don't really know what that is. wherever the physical therapy was being practiced on animals, it would have to meet requirements for animal facilities. That's just unclear. That's all I've got. Thank you.
And that would be under the Physical Therapy Act. So they would be the ones enforcing to make sure that the animal facilities met the local regulations, ordinance, and zoning requirements for an animal facility. So that's not even our board doing anything with that.
Go ahead, Dr. Grant.
So is there anything that prevents a veterinarian from hiring a person who's had physical therapy experience or training on humans, I guess, to perform like ultrasound or heat or whatnot in their own hospital under their supervision now? I mean, they can do that, and so we're not really depriving the public of a form of treatment at all, are we? We're just trying to monitor it and make sure it's done correctly at the right time.
Yeah.
I believe this bill states indirect supervision. That the second part of this bill is about referring to a physical therapist, so it's not under direct supervision of a veterinarian.
But that's why we want direct supervision
Yeah.
in the first place, right? And not really, I don't believe making that big a hardship for the animal physical therapist to come over to a veterinary hospital and arrange to have the animal there at the time, whatever.
Yeah, the board has taken an opposed position on this bill, not probably the specific bill, but anyway, has opposed this, and for reasons that I don't think has been resolved, or at least there were changes that were made considering the concerns of the board. So I don't see how we can support it now. Any other comments? Does anybody want to make a motion?
I'm moved that we take a stance of opposing this bill.
I second.
Who was first? All right, Dr. Maniak, you're seconding.
Okay, so now we open the floor for public comment for AB 1458.
Hello, Grant Miller from the California Veterinary Medical Association. AB 1458 is our #1 opposition bill for the year. Many of you have already discussed some of the reasons why we're very concerned about the bill. But one of the things that was not discussed that's relevant to this board is the fact that this bill is trying to override our definitions of indirect and direct supervision and rewrite them. We cannot have two definitions in law. And these definitions have been myopically taken by the sponsor of the bill and used specifically for physical therapy. But we use these definitions in regulations to identify the structure of a veterinary practice and how that works. If it is left as it is, we'll have competing definitions, which will cause confusion in our profession and result in a huge ripple effect in our regulations. The other concern that we have is that this board will have no ability to write regulations with its expertise on what should be in an animal facility, how the minimum standards should operate. That will ultimately be left to the physical therapy board, and they have no training in that whatsoever. This is very clearly the practice of veterinary medicine. It's being done on animals, and they haven't worked out very important considerations, such as in these physical therapy facilities, will a human being come in and lay on the table 1 minute and then a dog comes in and lays on the table the next minute? If you have a cat allergy and they've done physical therapy on a cat and they don't properly sanitize the room, the next person who comes in is going to have an allergic reaction to that cat. And these are all the things that they don't think about when they decide that they want to arbitrarily expand their practice act to include animals when they have no formal training or education in animals at all. If it were that simple, why would there not be a reciprocity clause in this bill to allow veterinarians to work on humans after a weekend certification course? CVMA would be happy to put one together and do that. Thank you.
Okay, any other public comment from the room? Oh, yes, we do.
Board, thank you. Okay, excuse me. My name is G.V. Ayers. I represent the Animal Physical Therapy Coalition and appreciate your the opportunity to be before you here regarding AB 1458. We appreciate the board for considering this. We're very grateful to Assembly Member Greg Wallace for authoring the bill, and we look forward to working through some solutions. I know you've identified some things such as enforcement and notification such as that. I mean, formal notification or registering with the board or the boards, as the case may be. We are working with Assembly Committee staff regarding some of those issues, and we look forward to going forward. We'll not go into tremendous detail here, but we look forward to the VMB at some point giving us consideration and input on how to move forward on this. I know that the board has said in the past that they would be encouraging and supportive of it, but there's never been any follow through with that. And we look forward to that and would like to do that. Would like to be able to sit down with you and talk about how to move forward with authorizing PTs to perform animal physical therapy. And with that, I'm going to conclude my remarks. Thank you.
All right. Thank you so much. Moderator, can you please open the line for participants participating remotely?
WebEx is taking public comment on 6A3. This is AB 1458. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. And our first request is coming from caller number 4. Hold on just a moment. I'm going to send you a request to unmute your microphone. You may need to dial *6 when prompted. All right, caller 4, we're going to try again. Oh, there we go.
Hi, am I in?
Yes, go ahead, please.
Oh, wonderful. Hello. This is Dr. Joanne Bach again, Doctor of Veterinary Medicine, licensed in California, and a certified rehab therapist. I just wanted to support the board and the CVMA in opposing this proposed bill in terms of I do feel that direct veterinary supervision is required in the performance of animal rehabilitation therapy. I don't feel that indirect should be allowed. This is based on almost 30 years now of veterinary practice experience, at least 20 of which has been formally in the practice of animal rehabilitation therapy. On a daily basis, I see that the veterinary patients and staff need supervision. We are, multiple times a day asked questions and clients in need of advice, staff members in need of advice moment to moment for adjusting plans and therapies, pain management, pain assessments. Just today alone, I had diagnosed 2 zoonotic diseases in my patients that need follow-up and particular precautions in a veterinary facility. I had a dog that was just diagnosed with a heart-based mass, special precautions needed there. had another dog present for a wound dehiscence. These are just things that are best managed by being overseen by a veterinarian, whether it be any scope of veterinary practice, much less even animal rehabilitation. I have worked with physical therapists. I respect their work. I'm happy to have them work under the direct supervision of a veterinarian. They definitely can still practice, but I do feel that that practice does need to be within a veterinary facility and not just referred by, you know, a general practitioner or other veterinarian that really isn't overseeing the case or having, you know, as much familiarity with the rehabilitation protocols needs. Physical therapists are not trained in, you know, the specific medical conditions. There may be contraindications to certain modalities, as well as, you know, other physical therapies and manual practices.
15 seconds.
So, you know, I, you know, certainly have seen examples of this and, you know, definitely firmly oppose the indirect, support the direct supervision.
Thank you. Next, we're going to hear from Karen Atlas. Hold on just a moment, please. We're sending you a request to unmute your microphone.
Hi there, my name is Karen Atlas. I'm the president of the Animal Physical Therapy Coalition. We are a diverse and growing alliance of veterinarians, physical therapists, registered vet technicians, and the animal owning public. The CVMA is no longer the only voice in California anymore. We now represent many of those vet voices now, advocating for access, collaboration, and animal welfare. The integration of licensed, specially trained physical therapists treating animals has come before this board multiple times, across 2 sunset reviews, and again now. For nearly 15 years, we've provided evidence-based data, yet it's often been ignored in favor of unsupported claims by the CVMA. In an age of misinformation, facts need to matter. We hope that day is today for facts, because access to essential care for animals is on the line. This is not a theoretical policy debate. It impacts real animals, real families, and real clinicians. AB 1458 addresses every single concern previously raised by this board while preserving full veterinary authority. It requires a veterinary exam, veterinary diagnosis, referral, supervision, and a written practice agreement. Veterinarians remain fully in control, and liability is clearly and appropriately rests with the licensed animal physical therapists. Further, there are clear mandated additional animal-specific education for the physical therapist in order to practice within this framework. This model of AB 1458 is safe, collaborative, and already proven. Colorado has used it successfully for 18 years, expanding access and creating jobs. Your own 2017 Stakeholders Task Force supported this exact framework where veterinarians determine the medical clearance and supervision level. AB 1458 also provides clarity to the public. The title Animal Physical Therapist is distinct and used only by licensed PTs with advanced animal training. This gives pet owners confidence and transparency in care. The bill also reduces the board's administrative burden by decreasing complaints tied to unlicensed activity. No licensed PT with advanced animal training has ever been the subject of a harm-related complaint. If this board is truly committed to protecting public and animal welfare, not professional turf, then supporting AB 1458 is the clear common sense path forward. The real decision today is quite simple. Should
15 seconds.
licensed veterinarians be authorized to refer to a qualified animal physical therapist and use their professional judgment on the level of supervision? Because AB 1458 clearly gives them that choice. Why not trust your licensees to do what's best for your own animal patients? Thank you.
Thank you. Next, we're going to hear from Carrie Clay. Hold on just a moment, please. We're sending you a request to unmute your microphone.
Hi, hello. This is Carrie Calais again. I'm a consumer and animal owner. As you know, I have cats. Um, I I want to just ask that the board support this effort um, to find some kind of accommodation between the animal physical therapists and the veterinary community. I wanted to completely support what Karen Atlas was saying. Um, I've been in on this issue since 2015 and was one member of the task force that was convened regarding animal physical therapy. And I can attest to the history of what's gone on. The last thing I would like to say is that I really am in favor of indirect supervision of animal physical therapists because I'm assuming that these physical therapists have been trained and are qualified to practice on animals with prior, examination by a vet and cooperation between the vet and the animal physical therapist. I frankly don't really want my animals to receive physical therapy from even if it's directly supervised from a veterinary technician or a veterinary assistant. I want them treated by animal physical therapists. So thank you very much.
Thank you. And that was our last request for public comment from WebEx.
All right, thank you. But I guess we have a public comment from the room.
Thank you. Ann Baxter from the CVMA, and I want to address, for the second year in a row, comments made by Ms. Atlas. I have one legal comment and one policy comment. And the legal comment feels very much like Groundhog Day because I made this exact comment in response to the exact same misinformation 1 year ago. Ms. Atlas trumpets the notion that there is some safe harbor for veterinarians under this bill. That the fact that the bill says, it's okay, move along, nothing to see here, no veterinarian liability, that tells the tale. It doesn't. And I will hearken again, as I did 1 year ago, to the concept of negligent referral and negligent delegation, under which a veterinarian can very easily be held liable for the dereliction of a physical therapist. Where does the delegation end? Where does it begin? Did the PT actually carry out the delegation appropriately? Was it appropriate in the first instance for the referral to go out to the PT? These are thorny issues, and you do not have to be Clarence Darrow to mount an argument against the veterinarian for a negligent referral or negligent delegation. So that's one thing. The policy argument is this. We keep hearing about this purported crisis, this access to APR crisis. There is no access to animal physical rehabilitation crisis in the state of California, in the United States, or on the planet Earth. That does not exist. And for Ms. Atlas and her colleagues to usurp a very serious access issue is an insult to you. It's an insult to the profession. And most importantly, it's an insult to the people in the state of California and elsewhere who actually experience real access to care issues. The solutions to those issues lie elsewhere. They do not lie with an APR bill. Thank you.
Okay, so I guess there are no other public comments. Now
All right, the motion is to oppose AB 1458. Ms. Pulowski,
Yes.
Dr. Bradbury,
Yes.
Mr. Espinoza, Dr. Grant,
Yes.
Dr. Maniak,
Yes.
Dr. Solocito.
yes.
Motion carries.
All right. Again, moving on to item 6A5.
Four, I believe.
No, 4. I'm sorry.
And yeah, we're at top of, we're at the top of page 5 on the memo. So AB 1502, as you may know, this is our sunset bill This bill declares the intent of the legislature to evaluate the board through the joint legislative sunset review oversight process and to subsequently effectuate any recommendations produced through that process. This bill also would require petitions for reinstatement and modification of penalties submitted to the board to be accompanied by a full set of fingerprints for purposes of conducting a criminal history record check. Under staff comments, staff anticipates this bill changing significantly with the legislative proposals you have all seen. I'll kind of defer to Jessica if you have any comments about the legislative proposals and next steps.
Yeah, so the proposals the board has approved so far has been submitted to the legislature. They're working with Ledge Council on some of the proposals going forward. They they are also open to receiving any additional proposals from the board that happened today, so they know that that's coming. And typically, we don't recommend certain positions on bills unless there's a significant negative impact to the board's operations. I highly encourage a support position for AB 1502.
I would hope we do that. So I am going to make a motion to support AB 1502.
I'll second that.
Now we open the floor for public comment for, what's it, AB 1502.
Grant Miller, California Veterinary Medical Association. I'll make it short. We're moving to a support position on AB 1502. Thank you.
All right, there seem to be no more further comments from the room. Moderator, could you please open for the public participating remotely?
Certainly. WebEx is now taking public comment on 6A4. This is Assembly Bill 1502. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no online requests, do you wish to continue with the motion?
Yes, please. Thank you.
Motion is to support AB 1502. Ms. Pulaski,
Yes.
Dr. Bradbury,
Yes.
Mr. Espinoza, Dr. Grant,
Yes.
Dr. Maniak,
Yes.
Dr. Solocito.
Yes.
Motion carries.
Okay, now moving on to Senate Bill 602.
Yes, Senate Bill 602. I'm on page 5 still of the memo. This bill pertains to VCPR and the existing law authorizes a veterinarian to allow an RVT to act as an agent of the veterinarian for the purpose of establishing the VCPR to administer preventative or prophylactic vaccines or medications for the control or eradication of apparent or anticipated internal or external parasites by satisfying specified conditions, including, among other things, imposing different requirements relating to the proximity of the veterinarian depending on where the RVT is administering the vaccine or medication. Specifically, existing law requires either that the veterinarian is physically present at the premises when the RVT is working at a registered veterinary premises, or if working at a location other than a registered veterinary premises, that the veterinarian is in the general vicinity or available by telephone and is quickly and easily available. This bill would revise existing law to authorize an RVT to administer the vaccine or medication in a registered veterinary premises that is a public animal control agency or shelter, private animal shelter, humane society shelter, or society for preventative of cruelty to animals shelter when the veterinarian is in the general vicinity or available by telephone and is quickly and easily available. And again, the fact sheet for this bill is attached to this memo. So I'll pause there again. If there are any questions or comments.
Okay, any comments from the board members? Do we want to have a motion for a position regarding this Bill?
I move we support this bill.
1502. Oh, no, 602.
1602.
I know, I keep going back, yeah. Second. Do we have a second?
I'll second the motion.
Now we want to open it for public comment from the room.
Grant Miller, CVMA. We're proud to co-sponsor this bill with the San Francisco SPCA and the San Diego Humane Society. Our aim is to increase access to veterinary care and help assist shelters in providing much needed services to the underserved population. This bill is just a small expansion, or maybe even you could say a fix-it of SB 669 last year, which, as you know, it allowed RVTs to become agents of the veterinarian in establishing a VCPR for providing vaccines. What we had overlooked there is that the RVTs, can go out to a location and do that work. But when they're in an animal shelter, the veterinarian has to actually be there at the shelter. And what they're asking from the shelters is just a very small expansion to allow the RVT in the shelter to provide rabies vaccines or other vaccines to the public without the veterinarian being there. So the same protocols are in place, the same requirements are in place. It's just a very small fix-it. So we are very appreciative of your potential support position. Thank you.
All right, thank you. So no more public comments in the room. Moderator, can you please open for any public comments from those participating remotely?
WebEx is open for public comment on 6A5. This is SB 602. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand. We will call on people in the order we have requests. And our first request is coming from Nancy Ehrlich. Hold on just a moment, please. We're sending you a request to unmute your microphone.
I'd just like to say on behalf of the California RVT Association that we support this bill. Thank you.
And that was our only online comment for this
Thank you.
motion.
Yes, we move to vote.
A couple things. Go ahead.
We have a comment from Tara.
I just wanted to raise for the board's consideration the legislation proposes to amend Business and Professions Code Section 4826.7, specifically subdivision B, paragraph 2. It would insert the ability to RVTs to provide specified services if working in a registered veterinary premises that is a public animal control agency or shelter, comma, private animal shelter. I don't know what is a private animal shelter. That could be somebody's house. That there's no limitation there. You could just call yourself a private animal shelter. There's no, nonprofit status requirement. So I would be a little bit concerned with just leaving that as is without a little bit more clarification.
That's actually what I was waiting for, is to hear from you on the language, because I was kind of curious on what that language meant with everything that was added. So
Wouldn't that be like I don't know, because the private animal shelters like the rescues, would that be,
A rescue is not a shelter.
right.
they keep animals, like multiple animals. Wouldn't that be considered a shelter?
Well, that's what I'm saying.
can
This
say-
is now confusing. Is it a
Right.
rescue group? We
So
have definitions
I
for
was
that.
going to say, you can ask for the author to consider adding, since rescue group is defined, well, or we're adding rescue group, right? But you can't. That's the concern. There's no definition of a private animal shelter, so we don't really know what that means. So we're asking I mean, so our motion is, can we amend our motion to say, to support if it's with clarification?
Right. You could submit a support if amended to clarify the term private animal shelter. I mean, the question is if it's clarified in a way that the board doesn't really support to include individuals who are hoarding animals, would you still support the bill? I mean, I'm not saying that's going to happen. I'm just saying you might want to be a little, perhaps you could request or do support if amended to clarify private animal shelter and delegate to the executive committee and executive officer the ability to communicate with the author's office and stakeholders to resolve the board's concerns.
So do you two accept that friendly amendment to your motion?
Yes. Yes.
Before we take a vote too, because we write the support letters to the legislature and we typically provide more rationale of why we're taking such position. But I know we've heard from public comment, but if we can just get some guidance from the board on the reasons for supporting. Otherwise, the letter is the board supports it.
Well, I guess we're supporting this because it is a response for, especially the access to care issues, where, and also knowing that our veterinarians can be very overworked. So being able to delegate, tasks that we trust, our RVTs and, be able to uh, uh, perform, responsibly. So I guess that's part of why we're supporting this bill.
Dr. Bradbury.
Dr. Bradbury?
I was just reading over this again. Whoops, what just happened? And the way it's worded to me looks like it has to be a registered premise. Where it says, if working at a location other than a registered veterinary premises, and then it's changed to, or in a, sorry, or in a registered veterinary premises that is, and then public animal control agency or shelter, private animal shelter, humane society shelter, or society for prevention of cruelty to animals shelter, which are registered veterinary premises. So doesn't that, because there's private shelters that are funded privately but act as shelters, if I'm not misunderstanding that. And so I feel like this is saying if it in a registered veterinary premises, and those are examples of the registered veterinary premises.
So do we have too many private animal shelters that are registered as veterinary premises?
I don't know the answer to that question.
I'd be surprised because typically it's like a registered veterinary premises and there's, an MGL. I don't know. I mean, I could see reading it that way, but I could also see reading it that the registered veterinary premises only applies to the public animal control agency or shelter, and then separately private animal shelter, separately humane society shelter, all of which are not registered veterinary premises.
But I think because that sentence starts off with other than a registered veterinary premise. So it's really covering our premises. It covers both. It covers those who are not registered or those who are registered. Right?
And to answer Jessica's first question, I believe it's to increase access to care and to help more consumers and pets get the access to care. I think that's our reason for support. So I think that's the reason for supporting this and to clean up this language that's already there, but I don't know that we're cleaning it up right now.
Perhaps members, since the co-sponsors are present, maybe ask them about the private animal shelter.
May we request the co-sponsor of the bill to clarify?
Thank you so much. Grant Miller, California Veterinary Medical Association. So these are all registered veterinary premises. In the current law, an RVT can act as an agent of a veterinarian in, let's just call it traditional premises like Christie's Hospital. They can work in exam room 3 all day long as an agent of the veterinarian doing vaccines and parasite control as long as the veterinarian is present in the building. Done. With SB 669, they also allow the RVTs to go out to a location like a park. And in that situation, the veterinarian has to be available by phone in the vicinity. Done. What this is doing is it's saying if the registered veterinary premises is a shelter or a humane society or a municipal animal control department or a private shelter like Mickelson Foundation, which is a private shelter, that RVT can still do the rabies vaccines, the regular vaccines for the public without the veterinarian being in the building. So it's always a registered veterinary premises. We're just asking for a special consideration for shelters who are mandated to provide low-cost rabies vaccines to the public, yet 60% of them don't have a veterinarian. They're all hiring. They can't find one. We're asking for that increase of an RVT's scope of practice within those shelters to be able to provide those vaccines with a veterinarian available by phone or in the vicinity. There are still protocols set up. All the agreements are still in place. There's just a minor expansion in the idea that the veterinarian is not on the premises when it happens. We do recognize, Tara, that private shelter is not defined, and thank you for bringing that up. I do think that's something that we could work to define. There are private shelters in California that are registered veterinary premises. I just named one as an example. But I do agree with you that we need to make sure that we're understanding who we are trying to extend this scope to.
Thank you. Does that clarify our question?
Yeah, I just want to keep an eye on how the changes to the exemptions from the practice of veterinary medicine under BPC Section 4827, subdivision A5, which already provides significant authority to administer certain treatments. And now, 669 already inserted, or 699, this additional authority. I just want to make sure that we're keeping an eye on how each of these are being expanded.
Thank you. Can I make a clarification? 4827 are exemptions from premises registration of shelters that only provide intake services to animals that are not necessarily the public bringing in his animal. So Justin's not going to bring in his animal to the shelter for services in 4827. 4827 is the animal control officers are bringing them in the back door. They're just doing vaccines, parasite control, and whatever their vet tells them to do. They're exempted from premises registration. 602 has nothing to do with them. This bill is for registered veterinary premises. So of the 330 animal shelters in California, roughly 230 of them are registered premises. The remaining 100 or so have said, look, we're not doing those types of services to the public where the public's bringing in their animals. We're just seeing animals come in the back door through animal control. They're the ones exempted in 4827. We're not talking about them. We're talking about the other 230 that are registered veterinary premises.
Yeah, it's extending the service to the public.
May I also say, I only think that the board's feedback can benefit this bill. Like, we're very open to hearing where we need to make the bill better to get at what I think we all know what we're trying to do. It's just like, the devil's in the details with the wording. And so we would very much appreciate any input that the board could have. I'll take back the private shelter thing to our focus group tomorrow.
I also just think it's important going forward if this bill goes into law, that we've got, some written documentation of what's happening, how this access to care is evolving, how there's, specific splits in authorized practice at specified locations. I think it just helps us, 5 years from now, and we're continuing to expand the scope of things. We have some intent behind the existing proposals. Thank you.
Thank you.
Yep. All right. So the motion is support if amended for AB 602. Ms. Pawlowski,
Yes.
Dr. Bradbury,
Yes.
Mr. Espinoza, Dr. Grant,
Yes.
Dr. Maniak,
Yes.
Dr. Solocito.
Yes.
Motion carries.
Now moving on to the next one.
Yes, the next item 6 on page 6 of the memo, SB 687. This deals with chiropractors, animal chiropractic practitioners. This bill would update the chiropractic scope of practice to allow doctors of chiropractic to deliver animal chiropractic services without the direct supervision of a vet if they possess a valid certification from either AVCA or IVCA. Chiropractors who are not certified may continue to practice animal chiropractic under the direct supervision of a veterinarian. Under staff comments, we just mentioned that the board did receive a presentation on animal chiropractic certification programs from representatives from AVCA and IVCA, and also discussed the potential for this bill. And then I'll just also note here, board staff notes that the board is not properly titled in this bill, referred to as the Veterinary Medical Board. We are now the California Veterinary Medical Board. And then we're concerned about the clarity of the board being required to informally vote on whether to adopt, amend, or repeal a regulation being adopted, amended, or repealed by the State Board of Chiropractic Examiners. There's a provision in there requiring that their board consult with our board on potential regulations. So I think we would just potentially like to request, I'm moving on to page 7, board staff recommend at a minimum the board vote to request clarifying amendments to the bill and authorize the board's executive committee and executive officer to communicate the board's concerns to the bill's author and legislative committee staff and work with the author to resolve the board's concerns. So again, I'll pause for comments or questions.
Does the board have any comments with regards to the staff recommendation? Go ahead, Dr. Grant.
Refresh my old memory, but when they gave their presentation, didn't we have part of the discussion on whether or not they were actually familiar with a number of the conditions in animals, especially like spinal things, and the people presenting it to me did not seem well versed in the conditions that can happen, at least with the animal's spine. And I thought there were going to be some outreach by that representatives of the animal or the chiropractic board to come and try to exchange knowledge or.
I think that was expressed, like the concerns, like the board still has concerns. It was not like a clear, like oppose or support kind of thing. So communication still need to continue. And that's why I think that's the recommendation, is for the executive officer to be able to have that authority to continue the conversations with the author's office. What does anybody think? Dr. Maniak?
I mean, it's similar to the physical therapy thing. We have provisions to allow for this to occur under direct supervision of a veterinarian. It's just as simple as that. I don't see why it needs to be changed.
So are you suggesting that we take an oppose unless amended or just oppose?
I motion to oppose SB 687.
I think Dr. Bradbury has a comment. No?
I think you have to wait and see if somebody seconds the motion.
Anybody wants to second it?
I'll second the motion.
We have our second, so
Okay. I just wanted to answer the question as to, where there were, why chiropractors might need to practice without a veterinarian. And I think this actually goes to the physical therapy as well. But, when I met with I guess it was the president of I'm not sure if that's the right title, of the Board of Chiropractic Examiners. He said at the time that there were chiropractors that were having a hard time finding a veterinarian that would follow them around in the field because they were large animal chiropractors or they wanted to practice on large animals. They were in rural Northern California, and there weren't enough large animal veterinarians in that area to begin with. And the ones that were there weren't going to be spending their time just following a chiropractor around to do their work. So that's, just one example of where they wouldn't be able to find a veterinarian to work under direct supervision. So I just wanted to put that out there.
I think this is a situation where there's a similarity with the situation that we have with the physical therapy, right? Where we do think that direct supervision is important. And I think because of the similarity, I just think that they're kind of the same. We're just dealing with a different group. So I think the sensible thing is to just basically oppose it the way that we've opposed the physical therapy proposal. Dr. Bradbury?
I'm not necessarily against opposing it, but I would just point out that this is different in that there is somebody actually like checking the qualifications in this case, and I believe either registering or licensing or a separate oversight by the chiropractic board. I agree that there's a lot of holes in the way that this is written, and and what the staff comments were. Those are concerning. But anyway, there's a difference in that regard. But if it's in regards to direct oversight, then it's the same.
Dr. Grant?
It's my impression that actually there are a lot of, especially large animal veterinarians licensed in the state who practice chiropractic forms of therapy. And so the argument that there's no one out there to provide the service or can't be, falls short for me for having a number of animals get their necks cracked around when they got a great big arthritic joint just because they're 100 miles from town or something, I mean, you know, that's not the horse's fault.
So is the board going to make a position or are we just? Oh, okay. We are now open for public. So I guess we're opening it for public comment. All right.
And for clarity, the motion on the table is oppose SB 687.
Hello, Dan Baxter from the CVMA. Dr. Miller will have more extensive comments, but just as one sort of overarching note, it's important to remember that the rubric here that you're being asked to analyze is not direct versus indirect supervision. In fact, the author and the sponsor of this bill, in contrast to the APR folks, I should note, are at least intellectually honest in coming right out and saying what they're asking for is no supervision at all. In fact, in their fact statement, first paragraph, SB 687 would add language to the BNP code to ensure that only those who have earned a DC degree and are properly certified will administer chiropractic adjustments to animals without the supervision of a veterinarian. So there is no supervision being called for under this bill. Thanks.
Grant Miller, California Veterinary Medical Association, was strongly opposed to any bill from a human healthcare practitioner who's attempting to arbitrarily expand their scope of practice to work on animals. It's deeply disrespectful to the veterinary profession. I feel that this bill actually deeply disrespects your board. It vests complete authority in the chiropractic board in determining regulations and rules as to how these people will practice essentially veterinary medicine on animals. They don't have any skill in zoonotic disease. They don't have any training in animal behavior. How is that board to know when a complaint is filed against a chiropractor whether or not they diverge from a standard of care or not? That takes veterinary expertise, but this board will have nothing to do with any of that. And so animals and consumers will be placed in immeasurable danger. There's a board that can't possibly have the expertise and knowledge and staff and skill to be able to analyze that. So these people will be left out in the cold with a sense of protection by a bill that's very poorly written. So from your board standpoint, I would hope that you'd want authority in regulating what is very clearly the practice of veterinary medicine. Thank you.
Okay, so moderator, can you please open the line for any public comments for those participating remotely?
All right, we are open for public comment via WebEx. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand. We will call on people in the order we have requests. We're going to take just a few seconds now. Oh, our first request is coming from Dr. Marissa Palmer. Hold on just a moment, please. We're sending you a request to unmute your microphone.
Hello.
Hello, go ahead, please.
Hi there. My name is Dr. Marissa Palmer. I am a chiropractor and I am the Director of Government Affairs for CalChiro, the California Chiropractic Association. Our mission is to empower doctors of chiropractic to enhance the quality of life for all Californians, and we believe that all Californians, whether human or animals, should have access to animal chiropractic care or chiropractic care. The two major components of this bill is allowing the public access to only certified and trained chiropractors who have certification and training through the AVC and IVCA. This is a very small group of individuals who have extensive training in animal chiropractic. The education includes matters as anatomy, biomechanics, functional neurology, veterinary sciences, animal diagnosis, chiropractic diagnosis, hands-on and adjusting techniques. Animal chiropractors, in addition to being human chiropractors with over 120 hours of undergraduate education and 4,500 of doctorate education, have to take a certification course, which is over 240 hours, including a hands-on and practical examination. We agree that only the most highly educated individuals should be touching animals. we don't believe that chiropractors with no education should be practicing animal chiropractic as well. The second component of this bill allows the chiropractic board to enforce these regulations. Just as the veterinary board has described earlier, the veterinary board does not license or register chiropractors, so they have to go through the citation route to go after chiropractors who are touching animals inappropriately. So having the chiropractic board enforce this will streamline the process and improve safety so that our board will also go after lay people who are using the word chiropractic and are not certified chiropractors. We appreciate the board continuing to have conversations and consider the importance of this legislation. Currently today, Tennessee just passed a similar bill allowing direct access to AVCA certified animal chiropractors. There are 6 other states currently that have similar language, including Arkansas, Utah, Colorado, Ohio, Oklahoma, and Nebraska. One of these states has been around since 2011, showing that this is a safe option for Californians. We also have letters from our main malpractice insurance carriers showing that there have been no claims against certified
15
animal
seconds.
chiropractors. So we look forward to continued discussion. Thank you.
Thank you. Next, we're going to hear from Carrie Clay. Hold on just a moment, please. We're sending you a request to unmute your microphone.
Hello, everyone. Yeah, I'd like to state my full support for the previous speaker and everything she said. And the reason I'm doing this is because I'm a client who's had an animal injured by a veterinarian who offered chiropractic adjustment. And I know this person was not trained fully as a doctor of chiropractic. This was a veterinarian. And I believe this person took some, well, they weren't a doctor of chiropractic, so they couldn't have had the full education that a doctor of chiropractic and then trained in animal chiropractic would have had. Fortunately, this was not a serious injury. It was just my animal was in pain for several days, and I swore that I would never have this person I would never agree to have adjustments made by this person again. So I would urge you to consider that fact, that you can't be training chiropractors from veterinarians over a weekend. So thank you very much for hearing me. Thank you.
Thank you. And those are all of our online requests. Oh, I take it back. We have another. Caller number 4, hold on just a moment. We're going to send you a request to unmute your microphone. You may need to dial *6 when prompted. Hi, go ahead, please.
Okay, Joanne Bach, DVM again. Similar to my prior stance, I would oppose this amendment. For years, chiropractors have been able to practice chiropractic medicine under direct veterinary supervision, and I feel that that's appropriate. I worked with a chiropractor for humans that did do so under direct veterinary supervision, was excellent, and followed the veterinary board direct supervision to a T, including asking if, hey, look at this animal, the client has a question, or they're wondering about supplements and so forth. So I think that's the appropriate way to do it. It's important for the safety of the animal. There are also veterinary doctors that are, quite a number of them that are trained and certified in specifically veterinary chiropractic medicine. I don't necessarily feel that there's a shortage, of that at this point. And there is some overlap in the rehab world of, some spinal manipulation and so forth that falls under chiropractic that also should be done, only by a veterinarian or under the direct veterinary supervision. Thank you, by the way, for hearing my opinions today. And I'm glad the technology has worked for being remote as I'm trying to squeeze this into my practice today.
All right, thank you. And I believe WebEx is finished with public comment for this motion.
Right, thank you.
All right, so the motion is oppose SB 687. Ms. Pulowski,
Yes.
Dr. Bradbury,
Yes.
Mr. Espinoza,
Yes.
Dr. Grant,
Yes.
Dr. Maniak,
Yes.
Dr. Solacito.
Yes.
Motion carries. And members, for the interest of time, in section B, the other board monitored legislation typically is an informational purposes, and we don't go through each item, but if the board would like to discuss any of the listed items, we are happy to do so. Any questions or want any discussions regarding the other monitored legislation? All right. Then I think with that, we'll move on to C. We have requested action. Go ahead, Justin.
Just grab my notes. I'm sorry, Jessica, I was going to ask you if you wanted to present that item.
Yeah, so just very quickly, the board had asked for amendments in our sunset report regarding 4887 for petitions for reinstatement, specifically regarding, hold on a sec, we have the attachment. So, and we're not sharing it, but regarding the surrendered individuals. So on, I don't know who's sharing the screen, but page 36 of 37. So we had asked in our sunset report for the amount tolling when it comes to the potential for reinstatement. When you look at 4887A2, we had asked for the time that was told not apply to the periods specified in B and C, but the board hadn't seen actual language for that. And then in B, regarding the full set of fingerprints. So for the petitioners who are petitioning for reinstatement, we're just requesting that the full set of fingerprints are also included in that petition. And so all this is doing is requiring, is showing you the language that we would like the board to opine on. And then I believe in F, the board had already saw that language and approved that, but it's already part of the proposal. The main things under the, so you see the double underline is adding actually, it says that only in B was the reinstatement, but I believe the tolling was also included. But mainly this is essentially something that the board had asked for, but didn't see the actual language of it. So this was just a procedural step for the board to approve. And then we could submit it to the legislature.
I could make a motion. A motion to submit to the California State Legislature the legislative proposal to amend BPC Section 4887 regarding petitions for reinstatement.
Oh, second.
Okay, now we open the floor for public comments in the room. I see no public comments. Moderator, can you please open the line for public comments for those participating remotely?
We are open for public comment on 6C as in Charlie. If you'd like to make a comment, please raise your hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take a few seconds now to see if we have a request for public comment. Seeing no request, you wish to continue with the motion?
Yes, please.
Ms. Pulowski.
Yes.
Dr. Bradbury.
Yes.
Mr. Espinoza.
Yes.
Dr. Grant.
Yes.
Dr. Maniak.
Yes.
Dr. Solocito.
Yes.
Motion carries.
All right, so we're going to take a 10-minute break and then we will resume. So it's 4:06. So we'll be back at 4:16.
We're actually going to take an item out of order to make sure that we have our student liaison from UC Davis able to make her report. So we're going to jump to 17A before we jump to 7.
All right. Go ahead.
Okay. Hi, everybody. Hello again from UC Davis. Apologies for my absence from the beginning of this meeting and the meeting in January. As always, the veterinary schedule is pretty wild, especially for a student. I'm just starting my 4th year, so it's getting really intense. So thank you for your patience. I'd like to start this off just by saying that this is my final announcement today as the board's student liaison. I want to thank you all so much for welcoming me here, giving me so much great advice, and always asking for my input on important subjects. I have very much enjoyed serving as a connection between my school and the board by conveying information, joining a committee, and just soaking up information about our Practice Act. With great pleasure, I will now introduce you to the person who is taking my place, a second-year student named Sebastian. Unfortunately, today our schedules didn't match up, so while they're learning about surgical technique in Gorley Hall today, and I'm beating my orientation to clinics, they will be online at the meeting, so you might see their name pop up periodically, and you're welcome to say hi and introduce yourselves. But I asked them to give me just a short bio so that I can convey to you who this awesome new person is. So Sebastian grew up in Ventura County. They were involved in small animal medicine through their family's clinic as a small child, subsequently working there starting in high school. Ever since then, Sebastian has pursued the field and has worked in several small animal clinics in lead roles, and they're now about to finish their 2nd year in vet school. In school, they remain dedicated to interests including small animals, wildlife, and exotics, with a focus on animal welfare in all of these areas. They also hold other roles, such as being a student ambassador for the Veterinary Information Network we live in, the treasurer and upcoming president of the Camelin Medicine Club, and current podcast director for the Students of One Health Club. Additionally, they are interested in politics as they relate to veterinary regulations, and they are very excited to work with the board and observe general proceedings in the coming future. So as I said, Sebastian will be online today and tomorrow periodically to listen to the meetings and get a feel for how they're run. So feel free to give them just as warm welcome you did me. And next, as I repeat every meeting, UC Davis would love your help. There are 2 areas that we are always looking for more veterinarian assistance. First, as mentors in our doctoring course, teaching client communication, especially large animal vet mentors, please. And second, as supervising veterinarians at our access to care clinics all over Northern California, including places like Knights Landing, Sacramento, and Covelo. Actually, Covelo's clinic just went out a few weekends ago and was very successful. If you're interested, please reach out to me and I will immediately get you in contact with the right people. With that said, I thought I'd keep my last announcement fairly short. Sebastian will update you all shortly with more information about their class, which is the class of 2027, and any additional upcoming information from the school. So thank you so much for your time.
Well, Holly, thank you so much for, being such a great liaison for UC Davis on the board. We definitely appreciate all the updates that you've provided the board, giving us a lot of insights on what's going on, building our new younger veterinarians. So I guess as a sign of our appreciation, the board would like to offer you the certificate of appreciation. And it says here, the California Veterinary Medical Board presents the following award to Holly Masterson in recognition of her service and professionalism demonstrated while serving as the veterinarian student liaison from the University of California, Davis College of Veterinary Medicine. Ms. Masterson provided invaluable insight to the board about the veterinary student experience and was essential in creating a bridge between the board and the students. Signed by myself and Ms. Pawlowski.
Much.
Thank you very much for all of your work. We do appreciate it. And you provide wonderful updates and very informative. And I think they help the veterinary community and the consumers and their pets. So thank you very much for providing those. So,
And we wish you luck.
Yeah.
Because you'll be graduating soon. And
I know.
you now, the people from the board. So don't be a stranger. If there's any concern or any valuable information that you think that the board should know about, feel free to reach out.
And in 5 years, we'll be hitting you up for an expert and an inspector.
Best of luck in your future career.
And we welcome Sebastian, and I don't know if they're on, but we welcome Sebastian.
Yeah. Okay. All right, so we're opening Holly's report for public comment from the room. I see no comment from the room, so moderator, can you please open it up for our participants online?
All right, WebEx is open for public comment on the Student Liaison Report. This is agenda item 17. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue with the agenda?
Yes, please, thank you. All right, we're going back to agenda item 7, agenda 7.
Okay, yes, agenda item 7A, status on pending regulations. Let's see, so since the January 2025 meeting, one regular rulemaking package was approved. 5 regular rulemaking packages are pending in various stages of the rulemaking process. And I'll just kind of go through them in order here. The first one listed is the veterinary facilities, Title 24, Section 1251 package. Last meeting, we did report that this package was approved by the Building Standards Commission. We're going through the process of reviewing the proofs for publication. We reviewed one first proof, and we just received notification that there's a second proof to review with a deadline of Monday. So again, this is the building standards proposal. It moves existing building standards and related exemptions from the minimum standards alternate veterinary premises proposal, moving everything over to Title 24, Section 1251, and moves from that section any practice management standards, which should be found under Title 16. And as I mentioned, this package was approved on December 17th by the Building Standards Commission. On January 10th, the approved rulemaking was filed with the Office of the Secretary of State. On January 13th, we were required to submit a formal hard copy of the rulemaking to the Building Standards Commission. On January 22nd, the approved regulations were posted to the board's approved regulations webpage. And then, as I mentioned, the commission is working currently with the International Code Council to publish all approved code changes into the 2025 California Building Code. On March 12th, as I mentioned, a first proof of board changes was approved by Regulations Council and board staff. And we do, as I mentioned, we did receive our second proof just this week, I believe, or earlier this week, with a Monday deadline to get back to them. So that's moving forward. These changes will become effective January 1, 2026. That's the first item. Moving over to page 2. In the memo is our minimum standards for alternate veterinary premises package, kind of the related package related to the Title 24. This proposal would standardize language utilized in modern veterinary practice and update the requirements for fixed veterinary premises, mobile veterinary premises, vaccination veterinary premises, and shelter premises. Additionally, the proposal would move, as I mentioned, all apparent building standards, including any exemptions to those standards from Title 16. The proposed language also provides for the need of large animal practitioners and limitations they have for equipment or movement of large animals, provides for the various mobile veterinary premises types, including house calls and services for equines or food animals, livestock, clarifies personnel authorized to provide vaccinations at veterinary premises, and the veterinarian's responsibilities. Also sets specified requirements for animal shelters. Currently, board staff is continuing to work with Regulations Council on this package. We're hoping to move it forward through the department, through second review, and onto the director for review, and hoping to get this package published with the Office of Administrative Law, shooting for May. So that's the goal here. The next package is our records package. A summary of what that package does. I'm not going to go through the details there. This will be the next package that I'll be working on with Regulations Council once we get the alternate veterinary premises package moving. So these are kind of in order, kind of the sequence that we're working on them. The next package has to do with drug compounding, and then just a summary of what that package does. I'm not going to go through it in detail. And again, this would be the next package in the queue that we'll be working on. And feel free to stop me if you have any specific questions. I'm moving on to page 4, I believe. So item 5, civil penalties for citation. This regulatory proposal is contingent on the approval and enactment of the legislative proposal to amend BPC Section 4875.2 and add Section 4875.7 regarding unlicensed practice citations. This proposal would remove references to unlicensed practice citations, as there would no longer be a need for unlicensed practice citations to be assigned a classification if the related proposal is successful. The update here, this proposal was approved by the MDC and the board at the January meetings. The next item on the list, item 6, out-of-state registration as equivalent. Again, another regulatory proposal that was approved by the MDC and the board in January. This proposal would repeal CCR Title 16, Section 2068.6, and would thus eliminate the experience-only pathway for RVT registration that currently only exists for out-of-state applicants. So just a quick summary of the regular rulemaking packages there. Moving down further on the page, we discuss our Section 100 rulemaking packages. And since the last meeting, we had 3 separate Section 100 proposals which were approved by OAL. The first one was intended to conform the regulations to change in statute related to California State Board and Veterinary Technician examinations, temporary licenses, California curriculum, appeals of examination results, and RVT continuing education credit. So this was mainly in response to eliminating the California exams. This package was approved by OAL on February 12th, filed with the Office of Secretary of State the same day, and this approved package is also posted on the board's approved regulations website. The second item on the last page of the memo just had to do with the updating the board's address and the name change from the Diversion Evaluation Committee to the Wellness Evaluation Committee. This package was approved by OAL on February 5th, filed with the Office of the Secretary of State, and it too is posted on the board's website. The third Section 100 listed on the last page of your memo, VCPR. This repealed CCR Section 2032.1 and amended CCR Sections 2032.25 and 2038.5 due to the statutory changes that resulted from SB 669 and Assembly Bill 1399. It was determined that Section 2032.1 should be repealed as it duplicated VCPR provisions found under statute. The 2 other amendments we're just updating the reference to the statute BPC Section 4826.6. That's where the VCR provisions are found now. This package was approved on February 12th by OAL, filed with the Office of Secretary of State the same day, and that concludes those updates unless there are any questions. And then, as always, the last or the attachment to the memo is just our spreadsheet that shows any updates since the last meeting. So anything in red text is an update since our last meeting.
Any comments from the board members? None? Okay, so now we open it up for public comment. So is there any public comment from the room? Okay, no public comments in the room. Moderator, can you please open it up for participants online?
We are open for public comment via WebEx on 7A. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no request, do you wish to continue with the agenda?
Yes, please, thank you. So now we move on to agenda item 7B. Yeah.
Yes, 7B. So this is a recommendation to initiate rulemaking to repeal CCR sections 2014, 2015, and 2015.2 regarding licensing and registration examinations. Two of these proposed, 2 of the sections that are being proposed to be repealed were part of the Section 100 change. The first one that I mentioned dealing with the elimination of the California examinations. As we were reviewing these packages with the OAL, they did question 2 of the provisions in that package. They deemed those 2 provisions, or at least repealing them, they deemed them substantive. So we were asked to exclude those provisions from the Section 100 proposal. So that's why there's the need to kind of do this as a second piece through the regular rulemaking process. So I'll try to be brief here. So the first, I'll move into the second paragraph in the memo. One proposed change in this package to repeal what was formerly CCR Title 16, Section 14, subsection B. It was not approved, as I mentioned. This provision deals with the grading method for the National Veterinary Examination and the administration of the, I'm sorry, I'm just going to talk about that one. The first one here. More specifically, the regulation in question discusses how the pass point for the National Veterinarian Examination is determined, and that passing scores may vary moderately with changes in test composition. Board Staff and Regulations Council explained to OAL that the board does not administer the national examination, nor does it have the authority over the examination vendors to dictate what a passing score is or how it is determined. Despite the explanation, OAL concluded that the proposed repeal of that regulation fell outside of the definition of a Section 100 change. So we were therefore asked to exclude that from the package. Let's see here. I'm kind of jumping around here. The second provision in question fell under 2015.2. I'm kind of jumping over to page 3 in the memo. That particular provision discussed the administration of the veterinary law exam by mail, which was the older method of administration. However, effective January 1, 2019, the board was given statutory authority to administer the examination via regular mail, email, or by other electronic means. Staff and Regulations Council explained to OAL that the underlying statute gives the board administration options, while the regulation only discusses the regular mail method. It's further explained that this unintended discrepancy between the statute and regulation can potentially lead to mislead the regulated community that the examination must be offered by regular mail when that is not the current practice of the board. And again, despite the explanation, OAL opined that the proposed repeal of that provision fell outside of the definition of a Section 100 change. Thus, the reason to pursue this through the regular rulemaking process. The third repeal would be Section 2015, and I might ask Jessica
You want-
if
I'll
you
take
could.
it.
Yeah, thank you.
Okay, so 2015 is regarding examination credits. This was part of the Section 100 package in that it struck the references to the state-specific examinations because they're no longer a thing. When doing that, when you look at C and D, the two examinations that were required within a 60-month period was the national exam and the state exam. So when you eliminate the mention of the state exam, you now have the reference to a 60-month period between one exam, which doesn't make any sense. And so C and D should actually be struck, which we likely could do in another Section 100. But when looking at that, now that the fact that we have two exams when it comes to veterinarians, so you look at A and B, you have the national exam, which is a high stakes minimum competency exam, and then you have your law exam, which is not a high stakes exam, it's open book, Survey Monkey exam, where to me, it didn't make sense to have this 60-month requirement on. One, I'm not aware of any time when we actually said, nope, you got to go back and take all exams. So I don't think that this has been triggered in at least the last 10 years. But on the offset, you have the situation where they passed, maybe they took the law exam and then they keep trying to take the NAVLE or the VTNE and say it gets to a point where they do pass that NAVLE or VTNE, it could be 5 years and a day later, this regulation would make them then retake the national exam, which seems kind of extreme and also something that I think the national examination vendors would oppose because they just took it. And it seems overly burdensome, and I don't think it's necessary. And then you have the flip side where I don't think that would ever be triggered, but you could have the fact that they took the exam and then 5 years later, they then passed an open book law exam. You have the already existing law that if they pass the national exam after 5 years, they have to either retake it, they have to prove clinical practice hours or continue education. So I think we're covered there. It just seemed unnecessary and overly burdensome and likely not successful if they try to actually have to take it again. So the recommendation is that all of 2015 be repealed.
All right. Do we have any comments from board members, questions, clarifications? Nothing? All right.
Yep.
Okay, it's late and everybody wants to just not read this. So I will make a motion to approve the regulatory proposal to repeal CCR Title 16, Section 2014, 2015, and 2015.2. Direct staff to submit the text to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review. And if the board does not receive any comments providing objections or adverse recommendations specifically directed at the proposed action or to the procedures followed by the board in proposing or adopting the action, then the board authorizes the executive officer to take all steps necessary to initiate the rulemaking process, make any technical or non-substantive changes to the package, and set the matter for hearing if requested. If after the 45-day public comment period, no adverse comments are received and no public hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and repeal and the proposed regulations as described in the text notice for CCR Title 16, Sections 2014, 2015, and 2015.2.
Second.
All right, so we have a motion and it's been seconded, and now we open it up for public comment in the room. All right, no public comment in the room. Moderator, could you please open up, online for our participants?
We are open for public comment on 7B as in Bravo. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand, and we will call on people in the order we have requests. As a reminder for our mobile device users, you may need to hit the ellipses button, that's the ... in order to find your hand. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue with the agenda or the motion?
Yes, please.
Ms. Pulowski.
Yes.
Dr. Bradbury.
Yes.
Mr. Espinoza.
Yes.
Dr. Grant.
Yes.
Dr. Maniak.
Yes.
Dr. Solocito.
Yes.
Motion carries. Yep.
All right, and with that, I guess we now go into recess and we'll resume session tomorrow at 9 a.m.